Thumbnail isn't clickbait, Tectone isn't guilty. And I hope you'll stay long enough to learn the nuance of why that statement is true, because I believe the lack of understanding from all angles on this subject matter is important to clarify. This probably seems out of place on my channel, but this is actually the third time I've made a video about this subject matter over my nearly 18 years on the platform, because I always find myself just incredibly angry when people treat this particular subject like drama and feeling as though I need to express that anger. Unlike those times where I did it as an outlet of my frustration and privated or deleted those videos, I think what I have to say will be genuinely helpful for people to understand what's going on and be able to look at things in a broader context. First things first, the day after the court date, someone under the username Wooden Badger joined Tectone's Discord and leaked a link to the case documents. You may have seen people claiming Tectone was a leaker, which would be incredibly stupid considering the supposed contents of those documents and the context of the protection order that was issued. You might have seen people saying Mizkif was the leaker, but do you really think Mizkif wouldn't chomp at the bit to get credit for being the first to have dirt on one of his least favorite people? The truth of the matter is, at this moment, we don't know who the leaker is, and if we ever do find out, it likely won't end well for them. Currently, the case is still not available to view through Travis County's record portal because a motion from the applicant was made to have them sealed. But the link and the documents are legitimate artifacts that exist within the portal by evidence of the link actually functioning under the Travis County, Texas domain. As of this recording, the only evidence remaining of this link I was able to find are screenshots with much of the address blacked out. It's possible the link in full still exists within Discord, but I'd hope Tectone and his mods would have the common sense to delete it. I brought this up first because it's important to know that it's impossible to 100% verify the authenticity of any screenshots you've seen on Twitter or the documents that have been reviewed in videos by people like Chud and Mizkif, because in their cases, the documents being reviewed were downloaded prior to review, as evidenced by the seed directory address in the videos rather than the Travis County, Texas.gov domain. That's not to say that everything you may have seen is fake, but this unfortunately is a set of circumstances about divisive parties that lends itself extremely well to manufacturing false information. That's also not to say the previously mentioned creators manufactured false documents or that they do not have the real documents, but there's nothing stopping someone from AI generating a fake case file and posting it to LSF for people to latch onto as though it's the real thing. If you don't see the file opened on the web page or the file being downloaded from the web page and open in the browser like in Destiny's video, it's important to keep in mind there are a lot of people that are more than happy to post things they think you'll want to see regarding the people involved. Now, here's what we can reasonably conclude based on aspects that are consistent with the postings of the document that have been shared. On January 7th of this year, a civil case was filed on behalf of online creator and former partner of Tectone, Pinkchu, seeking an extended order of protection against Tectone for family abuse, otherwise known as domestic violence, including sexual assault and stalking. The court found that family violence, including sexual assault and stalking, did occur and was likely to continue without intervention from the court, and issued an order of protection barring Tectone from communicating with or approaching Pinkchu in any manner, in addition to prohibiting him from possessing any firearms and requiring him to submit any firearms that may already be in his possession, which he swore under oath during the trial and submitted a sworn affidavit after the fact, testifying that he did not have any firearms to submit. So why did I say Tectone isn't guilty? Because this was not a criminal trial, it was a civil trial. Guilty was never something being sought. He was found liable. And if you've got any ideas in your head based on what you've seen other people saying regarding that, I promise I am not taking this where you may think I am, so hang on. So, What exactly is the difference and why is it so important? The difference is that a criminal trial is a case submitted by prosecutors seeking punitive measures, punishment, on behalf of the people in their jurisdiction. When a case is brought to a prosecutor, usually an elected district attorney, they observe the facts of the case and decide if it's worth pursuing. And that more often than not means that the prosecutor is certain they will get a conviction before the case even officially begins. If they think they can't win or force a plea bargain, they probably won't submit charges. You may have heard about how unfair the justice system is in Japan with their over 99% conviction rates, but the truth is the US isn't that far behind with an average of 95%, and in some districts those rates are as high as they are in Japan. And that's just the number that actually make it to trial. Most cases end up with plea deals before anyone even steps foot in the courtroom. Because the system is so unbelievably stacked in favor of the prosecution, criminal trials have the highest burden of proof, beyond a reasonable doubt. This means, ideally, when all relevant facts are presented, assuming all relevant facts are allowed to be presented, there exists no reasonable arguments that can raise any doubt that the person or persons being tried committed the offenses they are being charged with. That said, studies have been performed that show that around 30% of jurors decide how they'll vote after opening statements, but even that is counterweighted by preemptory challenges. That's when both the prosecution and defense get to examine the jury pool and remove select jurors they think will bias the case against them. The defense gets to remove up to 10 jurors, and the prosecution only gets to remove up to 6. And the final stopgap in the defense's favor is that the jury's ruling must be a unanimous 12-0 vote in favor of the prosecution to obtain a conviction. Before the case even begins, the prosecutor has to decide if they can clear all of those hurdles. All of these reasons are why a victim of sexual violence may choose to seek civil litigation instead of criminal charges. The sad truth is, you practically have to have video evidence, a rape kit or medical records, incident reports from the police, and/or additional first-hand witnesses for a DA to decide the case is even worth pursuing. The sadder case is, the same can be said for the lawyers of the victims. If they believe it's unlikely that prosecutors will seek justice on their client's behalf, they're more likely to encourage them to take a different route. And that brings us back to Pinkchu v. Tectone and civil court. Civil cases can be filed by anyone for any reason. If you don't like this video, you could, in theory, file a lawsuit against me. It will more than likely be tossed in the trash because judges typically CBA to deal with a case without merit, which, by the way, is another hurdle that exists in criminal cases too, but you could do it. Filing a suit is essentially just paperwork anyone can do if they're so inclined. When a suit is filed by a plaintiff/applicant, in this case Pinkchu, a summons will be issued to the respondent, in this case Tectone. When that summons is answered, a few things can happen. First, normally, the parties or their representatives will meet to decide if litigation actually needs to be pursued. If the parties cannot agree, the court will normally recommend that the parties meet in arbitration to come to a mutual agreement or an agreement that the arbitrator will decide for them. If that doesn't happen, they continue to meet and attempt to settle the case. If that doesn't happen, a judge will decide what to do from there. They can dismiss the case outright if they feel there aren't facts that need adjudication. They can issue a summary judgment and just decide the case then and there. Or, if there are substantive facts that need adjudication, they can schedule it to go to trial. In our case here, that's what happened. Both parties made it through all those barriers that normally put a stop to litigation for a judge to decide that there were substantive facts within the case that needed to be heard. It is not he said, she said. The judge, in this case a judge that has a massive backlog of dockets of cases that will determine if a parent is fit to keep their child, visitation rights, divorce proceedings, and countless other things that must be seen to, has seen the facts and the evidence of the case and decided that it is substantive enough to include on that docket with those issues. That could be because the evidence from the plaintiff is convincing, or the respondent has evidence that is potentially exculpatory, or even that both have evidence that need to be weighed against each other to make a decision that must be made by the court. Both parties in civil litigation are considered to enter the cases they're involved in on equal footing. Though there is an asterisk here because representation is almost never equal in civil or criminal litigation, as far as the court is concerned, the facts of the cases are both equally favorable and disfavorable to both parties, and thus the burden of proof in civil litigation reflects that, a preponderance of the evidence. That means the case is decided either by the judge or by a jury if the parties choose to have one, based on what is more likely than not to be true. It's often said that means at least 50 point anything percent or higher, but that's an oversimplification. If there's no jury, that is pretty much true though. The facts rule in one way more likely than not by any degree. If there is a jury, they decide under that same metric, but still require a majority vote, and not a simple majority either. In Texas, 5/6 of the jurors need to be in agreement on the weight of those facts to reach a verdict, which is reflected at the rate at which plaintiffs succeed in the US. Most people think the lower burden of proof means rulings in favor of the respondent in civil trials are harder to get than they are in favor of the defendant in criminal trials. But keep in mind, in criminal trials, the defendant's odds are 1 to 5%. In civil trials, that jumps to 32% in bench trials decided by the judge, and 46% in jury trials. It's still not in their favor. After all, it's unlikely to make it to trial in the first place if there's no merit, but it's by no means the unfair her word against mine you may have been led to believe it is. For the record, as far as I can tell, this was a bench trial, which is utterly baffling to me considering Tectone definitely had the resources to get a jury trial if he wanted it, which I'd imagine his lawyers would have tried to convince him that he did. So what does all of this mean? It means after all was said and done, all the evidence was presented, and all the arguments were made from both sides, the court formally decided that Pink Chew's complaints against Tectone were true. In the opinion of the court, Tectone did stalk Pink Chew. In the opinion of the court, Tectone was abusive to Pink Chew. In the opinion of the court, Pink Chew was in danger of further abuse from Tectone if they did not take action, and yes, in the opinion of the court, Tectone did sexually assault Pink Chew. It also means that if Tectone continues the abuse the court believes he inflicted on Pink Chew in any way, or if he is found to be in possession of a firearm, he can face criminal charges for violating the protective order they issued. If he does violate the protective order, he will not face criminal charges for the determined abuse, stalking, or sexual assault. Those issues, in all likelihood, will never be litigated again. Now, I want you all to take notice of how I described those meanings. What I described was justice for Pink Chew, not justice for gotcha players, liberals, or uninvolved content creators. This is not your or their win. It's hers. This is a case of a woman who saw no other solution to her abuse than to seek justice from the system. Not Twitter, not Reddit, and she got it. This isn't internet drama. This is justice for the pain, violence, and trauma inflicted onto one woman by one man. It's not something for anyone to celebrate but her and her loved ones. It's something that had to happen as a result of something that should have never happened. This isn't the villain you love to hate getting their just desserts in your favorite game or anime. It's justice, and it doesn't belong to you. It was not the people versus Tectone. It was Pinkchu versus Tectone. A real woman, by the judgment of the court, suffered a real tragedy. And even if it was the people versus Tectone, I want you to remember that treating this tragedy as though it's some kind of game you're scoring points in, or is something to use to gain social capital, something that is in any trivial way somehow beneficial to you, does nothing but water down the severity of that tragedy until it and similar tragedies are viewed as nothing more than tea.